And Ms. Smith, I know you filed a motion for continuance, but are you ready to move forward?
Just for the record, I'm not ready, but I have to be ready in some form. So yes, I will answer yes.
Okay, thank you. We will proceed then with this compulsory discipline matter. And for this matter, counsel for both parties are requested to address the issues of finality of judgment, the factual or legal basis for a conclusion that the conviction is an intentional crime, and the appropriate discipline in the case from your perspective. Would counsel please state their appearance for the record?
Judith DeBerry for the Commission for Lawyer Discipline.
Ms. Smith?
Deanna Jefferson Smith, State Bar number 24046152, respondent.
Thank you. Ms. DeBerry, would you like to make a brief opening statement?
Just briefly, may it please the board, this is a compulsory discipline case based on the respondent's conviction on September the 30th, 2020 for theft or embezzlement in connection with the health care in violation of 18 United States Code Section 669 in the United States Court for the Northern District of Texas, Dallas Division.
Thank you. Ms. Smith, would you like to make a brief opening statement before we proceed, or you can wait until after the commission has presented their case?
I'll wait.
Okay. Ms. DeBerry, you may proceed.
Sure. Thank you. We filed our petition for compulsory discipline on June the 8th, 2021, and the respondent was personally served with the petition and notice of this hearing on June the 28th, 2021 by Anita Skillern, a private process server. Proof of service has been on file with the board since July the 9th of 2021. On February the 6th, 2018, in cause number 3:18-CR-00068-K, style the United States of America versus Alicia Belfry Farley, parents 01, close parents, Deanna Jefferson Smith, parents 02, close parents, in the United States Court for the Northern District of Texas, Dallas Division. Respondent was charged by indictment with count 1, false statements relating to healthcare matters and aiding and abetting in violation of Title 18 United States Code Section 1035A2 and 2. And count 2, false statements related to healthcare matters in violation of 18 United States Code 1035A2. On or about March the 2nd, 2020, a plea agreement was entered in the same cause, styled United States of America versus Deanna Jefferson Smith, in the United States District Court for the Northern District of Texas, wherein the respondent pled guilty to count 1 of the information charging a violation of 18 United States Code Section 669, that is, theft in connection with health care. Defendant agreed to pay the United States District Court clerk the amount of $100 in satisfaction of the mandatory special assessment, and the government would dismiss all remaining counts at sentencing. The defendant agreed to make full restitution of the tax loss and would pay the United States District Court a special assessment in the amount of $100 per count of conviction. On March the 3rd, 2020, an information was entered in cause number 3:18-CR-00068-K, style United States United States of America versus Deanna Jefferson Smith, wherein on September the 7th, 2015, Smith knowingly and willfully stole and converted without authority to the use of BS, a minor who was not the rightful owner, payment of certain medical services from Neighbors Emergency Center the property of the Federal Employee Health Benefits Program in violation of Title 18 United States Code Section 669. On September the 30th, 2020, a judgment in a criminal case was entered in the same cause number wherein the respondent pled guilty to count 1, 18 United States Code Section 669, theft or embezzlement in connection with the health care, and was sentenced to probation for a term of 2 years and further ordered to pay an assessment of $25. At this time, I would offer into the following exhibits. Exhibit 1 is a certified copy of the indictment dated February the 6th, 2018 in cause number 318 CR 068-K style, the United States of America versus Alicia Belfry Farley, 1 in parentheses, and Deanna Jefferson Smith, 2 in parentheses. Certified copy, Exhibit 2 is a certified copy of the plea agreement dated March the 2nd, 2020, the same cause number styled United States of America versus Deanna Jefferson Smith. Exhibit 3 is a certified copy of the information dated March 3rd, 2020 in the same cause. Exhibit 4 is a certified copy of the judgment in a criminal case dated September 30th, 2020 in the underlying criminal case. Exhibit 5 is my original affidavit attesting to the fact that the respondent is the same person as the person identified as the defendant in the underlying criminal case. Exhibit 6 is the original certificate of Blake A. Hawthorne, clerk of the Supreme Court of Texas, dated July the 7th, 2021, indicating that respondent is licensed and currently authorized to practice law in the state of Texas. And finally, Exhibit 7 is a certified copy of a judgment of fully probated suspension dated October the 18th, 2017 in grievance case number 2015-06806. At this time, I would offer these exhibits.
Ms. Jefferson Smith, do you have any objections to the exhibits 1 through 7?
No objections.
Exhibits 1 through 7 will be admitted.
We respectfully seek an entry of judgment of disbarment.
All right. Thank you, Ms. DeBerry. Ms. Jefferson Smith, you may proceed.
I would like to, first of all, just make a quick opening that I would like to not be disbarred as I am currently. I've currently, it just seems like I keep paying for this horrible decision that I made, the bad decision that I made back in 2014, and I'm still paying for it today. And I would, can you give me a second, please?
Yes, and I understand this is your opening, but at the point where you want to provide testimony to the board, we'll need to get you sworn in.
Okay, so since I'm currently on probation with the federal government in regards to the misdemeanor charge of theft of health insurance, I would like to appeal that I have been reprimanded publicly. I'm on probation. I can't take any cases without approval from the judge. I know it says the approval from my probation officer, but Judge, I can't even think of his name. He's the one who I have to go in front of him each time I want to take on a new case. I have not done that.
Is it Judge Kincaid?
Yes, Judge Kincaid. I'm sorry. Sorry, Judge Kincaid. I forgot your name.
Okay, I would respectfully request that Ms. Jefferson Smith be put under oath at this time because it appears that she's testifying.
Ms. Smith, is this just opening argument or is this your testimony?
This is opening of what I'm asking for in relief and asking that you deny the state bar of disbarring me as a relief. And that's what I'm asking for, because I'm already on probation and very restricted in my law practice. And that's the only income I have at this time, because my husband died and that was all of our income. But I would just like for not to be disbarred and to finish out my probation that I'm currently on, which is very restricted practice in the law. And I just don't want to lose my bar license. Thank you.
All right, let's put you under oath. Would you like to provide testimony to the board today?
Yes.
Okay. Would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you will give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may proceed.
Okay, so when this first started with Alicia Farley was the complainant that filed the grievance against me back in I believe it was 2015. In 2016, I went to the state bar in response to a letter sent out by the investigator, Robin, and I can't remember his last name. And when I went to that meeting, I was informed of everything, the loan that Ms. Farley, the complainant, said that she had given me a loan. I said it was attorney fees. And so they had that information. The state bar had that information about the loan. They had that information about the health insurance. And they had that information about, I think it was an IOLTA. I didn't open an IOLTA. So those were the three charges that the state bar brought up back in 2016. And, and I agreed to the 1 year public reprimand because Kirsten would not, who was the prosecutor for the state bar, Kirsten wouldn't do would not agree to a private reprimand because of the insurance issue that that had come forth. That I informed them that I had done that I had given Miss Farley my children's social security number to put on federal. I know, I thought it was federal insurance, but it was her personal insurance. And so I did that. And then the feds came by my house to ask about Alicia Farley. And I informed them that she had filed a complaint against me and I was in front of the state bar and what the issue was. And I even told them about the insurance, which seemed to have been the biggest issue at that time. Then the feds took that information. They filed against me and Alicia. I think she pled guilty to a felony of fraud of health insurance. And mine was downgraded to a misdemeanor. Sorry. And then I was, and during this time, my husband was dying. Of cancer. And I couldn't defend myself in either of those situations. My husband had informed me because he was a witness, but he informed me that, he said, Deanna, whatever you do, don't take a plea, you fight. If you go down fighting, because that's what we're going to do. We're fighters. And I promised him that I would fight, but I don't have any more fight in me. And so when I was in front of Judge Kincaid and he gave me 2 years probation, could not practice law without approval. And then I had to go to, I got to go to counseling every other week. I was put on meds. And then I was informed that I had to self-report this, the federal case to the state bar. And that's what I did. I did that. And we're here, but I feel like I'm being double punished on this because the state bar was aware of the insurance at that time, just because the feds had not filed a case against me doesn't mean that they weren't aware. And they used that to get me to a public reprimand. And I had to pay, well, I was ordered to pay in the state bar case, I was ordered to pay the attorney's fees, and it came out to like $9,000 and some change. And so after my husband died, I couldn't pay it. And so they waived the remaining, but I had paid on time all the way up until my husband died. And then it was presented, I believe Heather White presented it to the state bar. I don't know what division, but the remaining fees were waived because I had no income at that time. And the only income I have now is my children that are dependents of my husband. They get his Social Security. And so that income, and then I get 2 more years of his disability. I mean, not disability, 2 more years of his retirement, but that's penalized excessively because I'm not 59 and a half. But I don't understand, why do I keep paying for this decision that I made to be friends with someone who wasn't a friend? And the horrible, horrible decision that I made 7 years ago is still in my life today. And I understand that when I have to be held accountable. I've held myself accountable. I've been held accountable, and I just feel like it's just too much. I mean, I just don't want to lose my bar card. I want to be able to practice law, and I will limit it to just the CPS cases in Tarrant County, and no other cases will I accept. And as a matter of fact, the judge called me yesterday from Judge Brown from the CPS courts in Tarrant County, because they were concerned because I had missed the final trial. But I was dropping my daughter off at college and just grieving so much. But she called and was very concerned about me. And so I will not take appointments from them, which I agreed with her. I will not take those appointments for 2 to 3 more months. So I won't even have those cases. So right now, I don't even know how I'm going to survive financially if you disbar me. But I'm a good person. I really did. I made a horrible mistake. But overall, I mean, I'm a good person. And it looks like that I was in trouble with the bar back in 2016. Now I'm in trouble with the bar again, but it's for the same thing. I'm not a person that goes out and does things like that. And I believe more than likely that I was just trying to fight for my husband to survive. And I lost that battle. But I would just like to just continue with the federal probation on the misdemeanor count. And because believe me, that's that is a punishment within itself. But I would just like to appeal to you guys, to all of you, get vaccinated. But I have a child left at home, and I have 2 in college, and I have 2 adult children, and then I have 2 grandchildren that I have right now. But And I feel like I'm rambling on and on and on because I was nowhere. I'm just not prepared. But I would just like to appeal to your humanity side of this will never ever happen again. As a matter of fact, if you find it in your heart to not disbar me, more than likely I will just move to Oklahoma and live out the rest of my days, whatever those look like, because that's where I'm from, is from Oklahoma, a small country town in western Oklahoma out in the middle of nowhere. And I'll just move there for the rest of my days. But if you disbar me, then I don't have any income or anywhere to go. I just, please don't take my license. I've lost everything else.
Ms. Smith, we're very sorry for your loss. What is your argument about the discretion that the board has as far as a range of punishment that it could issue today?
I don't know what that range is. All I know is that they're asking to disbar me. That's all I know. I don't know what's at the other end of the punishment range.
Have you finished your testimony?
Yeah, I've done the
I
best I
have some
could.
questions.
Yes.
Mr. Gregory, did you have a question? We didn't hear it.
Yes, I did. I do. Ms. Smith, I lost my wife to cancer also, but be that as it may, feel like I have a duty to ask these questions. Do your adult children have a job?
My two of them do. One, my oldest one has his own family. He lives in Fort Worth. And then my 27-year-old he lives in Austin and he works in Austin. And then my 24-year-old just left, going back to Midwestern State in Wichita Falls. And then I just dropped my 18-year-old off, who's the only girl of 5. I just dropped her off in Marshall, Texas at Wiley College. But no, they have jobs, but they have their own lives.
Do they have does your daughter have a scholarship?
No, she qualified for Pell Grants because of my income. And then I had to pay I have to pay $150 a month on the balance. The balance is for the semester is $2,000 per. It's $4,000 for the whole year, but I have to pay $150 a month for that. But other than, I mean, she got a pretty good lump taken care of during the with the Pell Grants, but she didn't get any scholarships.
What about your son that's in Midwestern?
This is his last year. He started out on a football scholarship, but after his dad died, I'm sorry. After his dad died, who was a football coach in Mansfield, and they're actually going to name a building after him. But after his dad died, then he walked away from football. So he's just there. And I had to get a loan last year for him to get through last year. And then I don't know what this year looks like for him as far as finances.
Have you investigated jobs as a legal assistant?
No, I mean, not actively. I thought about it. And that's what I said. If I go to Oklahoma, that's probably what I'll do as a legal assistant for my high school friend that is an attorney there. But I thought about it. And then my court appointed attorney on the federal case, Camille Knight, she made the suggestion that they had at her firm, they have some attorneys that are now paralegals there. So those are options after I guess after I land out on my feet, however I land. But
What do the paralegals in Texas make?
I have no idea. I didn't actively research it. It was just thrown out there as an idea. If I am disbarred, it was just thrown out there that would be an option.
Okay, thank you.
Yes.
Clarify for us, the healthcare fraud, was that in connection with your representation of this client, or was it unrelated? I'm having difficulty understanding the relationship between the two things.
Okay. I don't want to make a long story short, a long story longer. I met them at my husband's football game. Alicia and Andre Farley, we became, they were my clients at first, and then we became closer, became more like a family. And so I was informed, well, my children were on my husband's insurance, who was a teacher, but my son was having seizures and my husband was getting sick. And so Alicia Farley then says, well, since we work for the federal government, because they were correctional officers at the prison, since we work for the federal government with Obamacare, we can take on other people on our insurance to make sure that everyone's covered. And so my husband didn't believe that. And so we went over to their house and she called the insurance, who I thought was the insurance. She called the insurance. I asked all the questions, said it was perfectly fine. Plus she had other people on her insurance that were not her dependents, that did not live in the house. And so, so then I went ahead and I said, okay, then yeah, we can put my kids on your insurance. And so that was the beginning of the end of the relationship and everything. But that was the reason that Alicia Farley is, I don't want to say she's the reason for this, but that's where it's the same person. She's the same person that was in the health insurance fraud with me, or I was with her. And she's the same person that said that she lent me money. And she's the same person that I was indicted with.
Okay.
Thank you. Any other questions from either the board or Mr. Berry?
No, I have none.
Any questions from the board? Okay. Mr. Berry, would you like to make a closing argument?
I'd like to respond to some of Ms. Jefferson Smith's allegations. Number one, she said we knew about this at the time. Well, we may have, the judgment was entered based on her failure basically to advise her client that she had a right to independent counsel before making the loan, and the panel found that it was a loan. The other thing is she was also sanctioned because she did not have a trust account where all advance fees needed to go. Instead, she put them into her operating account or a personal account. The judgment was in 2017 was when that was rendered, and the criminal charges were not brought until 2018. So they were, none of the allegations, while they may have discussed some of this, I have no idea, I wasn't there, but none of the rules charged nor found included an 8.04A2, which would have been the charging a criminal act. So this is a totally different matter. It doesn't, while it may involve some of the same people, it is not the same set of facts that her probation or her fully probated suspension was based on.
May I respond to that or no?
Let her finish what she has to say, and then you can respond.
So I think based on that, while some of the same people may have been involved, and none of us were at the hearing, none of us were in the deliberations. Ms. Jefferson Smith was not in the deliberations with the panel. Those are totally confidential. So we don't know what they considered when they, decided on the appropriate sanction to impose. And it's not uncommon to have a sanction, especially when there are trust account violations that include a suspension. That's totally within the realm of what's acceptable and what would be appropriate in that circumstance. So that would be my response to some of what she has said. This was directly related to her practice of law in that it involved clients that she had. And I think by her own testimony was, I don't know if it was a way to pay their expenses or exactly how that worked. But it seems that this is a case where, a sanction is definitely required under the rules. I don't think the board they may have discretion whether to suspend her or to disbar her, but one of those two sanctions must be imposed according to the rules.
Anything else, Mr. Berry?
No, not at this time. Thank you.
Mr. Berry, this is Michael Gross. If I could,
Sure.
please, what is CDC's position on suspension?
We would ask for disbarment. This is the second, if you look at her suspension, again, she didn't have a trust account. It involved money issues. This involves money issues. This is directly related to her practice of law. And I think under, I look at some of the other associated or the factors, conduct during these proceedings, she didn't even file an answer until the very last minute. As far as I know, and I did talk to her probation officer, she is in compliance with the conditions of probation. We haven't heard any testimony regarding her efforts at rehabilitation. The credibility and under oath is your determination. And then the prior discipline I've provided to the board. So those are the newer factors. I think the others are pretty self-evident. The damage to clients, the possibility of future harm to clients or to the public, which in this case, it really speaks more to the public. So I would respectfully request disbarment. Does she have any other questions?
Any other questions for Mr. Berry? All right, Ms. Smith, you can respond and give your closing remarks.
As far as the panel that, the disciplinary panel that I went in front of regarding the grievance, I had agreed to the public disciplinary. They didn't make that decision. I had already agreed to it. I have the email with the order on it that has the insurance in the order, in the agreement of public disciplinary for a year probation, fully probated, if that makes sense. But I have the email, and that was sent to me 2 weeks before we went in front of the board, the panel, discuss the attorney's fees and the court costs. And so I had agreed to that. They didn't issue that punishment. I had agreed to that. And so I do know that wasn't even discussed during that panel review. It was just for the attorney's fees that I had to pay. And again, I reiterate that it is the same set of facts. It's the state bar knew about the insurance that I eventually pled guilty to later on. And I am not a harm to the public or to especially that particular client or to my other clients. I feel like I've learned my lesson. I've been held accountable. I'm probably harder on myself than anyone else. And I just feel like if I'm disbarred, then I'm not gonna know. I guess I don't know, I'll be homeless, I'll be without. So, which it only brings in, I only make probably $300 a month with my law practice, maybe. I haven't even billed the courts for any of my work since I've been doing this, because I'm just tired of dealing with this same issue. And it's very, very stressful. I believe that was one of the reasons that my husband couldn't fight, because we were so stressed out behind this. He couldn't fight the cancer. But I would again ask, I don't think it's mandatory that I'm disbarred or suspended. I think that's at your discretion, but I would like to appeal to allow me to finish out my probation with the federal program, federal courts, and let that be my punishment for this as well. Because I really need however much money I can make from those CPS cases. I just need that to pay some bills. And if I don't have my bar license, then I will have to find other work somehow or another. But I would appeal to, if I am at the least suspended, that I could still practice law under the suspension. I don't even know if that's possible, but if so, I would. But this is not a recurring action. And like I said, that's what the state is making it seem like, that it's a recurring action, that I was disciplined and then I went out and did something else, and now I'm in front of the bar again. And it's not. It's the same thing that I'm in front of the bar for, and it's the same thing that's on my bar license now. That the public reprimand, the order is on my bar license. So it's not that I keep going out doing things that I know that I'm not supposed to do. I did one thing and I'm continuing to pay for it. And I would just ask you to please stop the pain, and so that I can figure out what to do next with my life. Thank you.
And Ms. Smith, it's the commission's position, and it's my understanding as well, that the board's discretion is limited to either disbarment or a suspension through the term of your probation. I take it that you don't have any arguments that we have greater discretion than that?
I don't have any arguments, because like I said, I was not prepared for this. I've just been going through some things, but I would, is it mandatory that either one of those, that you do either one of those? Do you have to?
Well, that's the commission's position, and I'm not aware of any arguments to the contrary.
Well, my position would be to ask that since I'm already on probation with the federal government and really restricted in what I can practice and how I can practice, that would be punishment enough that it isn't mandatory. The motion to file the motion was compulsory. They had to do that, but the order or the punishment that I receive, I believe that you have the discretion to just, I guess you would say, bootstrap this case to the federal case. And I'm already on probation and going to counseling and did my community service. And I've been doing everything correctly. So I would ask that in your discretion that you would, at the most, allow me to continue the probation terms and conditions with the federal government and dismiss this case.
Any other questions from the board?
I have one, ma'am. Ms. Smith, just out of curiosity, you responded to the CDC, but you didn't respond directly to this board. Is there a reason why for that?
Well, because when I responded to the CDC, I hired an attorney. And so she was taking care of all of that while I was fighting for my husband to live. This time I didn't, I was just going to, I wasn't going to show up or anything. I wasn't going to fight today. And then I had a counseling session and was informed that I needed to fight. I needed to do this for my mental health. So that's why I responded this morning, because I wasn't going to at all. I was just going to let you guys take my bar license and just figure out what to do next, if there's anything to do next. But that's why I'm just tired of fighting, but I got to stand up for me because no one else is here to do that. So that's why I didn't respond, or I responded very late. But like I said, the CDC, I had hired Deborah Dame as my legal representation.
Thank you, ma'am.
Other questions from the board? All right, thank you. We will take this matter under advisement. And Ms. Smith, you are excused.
Thank you.
Thank you.
Do I need to stick around or am I done?
You're through. We'll issue an order in the next day or so.
Okay, thank you.
Thank you. All right, we will take up case number 63669, in re Rodolfo Delgado. Ms. Cates, are you ready to proceed? If you can unmute yourself.
There we go. Yes, ma'am. Sorry, my screens went back and forth.
Okay, Ms. Truitt, has anyone on behalf of Mr. Delgado appeared?
No, they have not.
Okay, and as I mentioned earlier, Mr. Gross is recused from hearing this matter. At this time, Ms. Cates, you can proceed.
Thank you. Again, I'm Amanda Cates on behalf of the Commission for Lawyer Discipline, and may it please the board. This is a motion for entry of judgment of disbarment against Rodolfo Delgado pursuant to Part 8 of the Texas Rules of Disciplinary Procedure. On or about October 1st, 2019, a judgment in a criminal case was entered in cause number 418 CR 00115-001, styled United States of America versus Rodolfo Rudy Delgado in the U.S. District Court for the Southern District of Texas, Houston Division. Wherein respondent, Mr. Delgado, was found guilty of count 1 SSS conspiracy, count 2 SSS federal program bribery, count 3 SSS federal program bribery, count 4 SSS federal program bribery, Count 5, Travel Act. Count 6, SSS Travel Act. Count 7, SSS Travel Act. And count 8, SSS Obstruction of Justice. Mr. Delgado was committed to the custody of the Bureau of Prisons for 60 months, with the term consisting of 48 months as to each of counts 1 through 6, counts 1, 5, 6, and 7, sorry, and 60 months as to counts 2, 3, 4, and 8. All terms were to run concurrently for a total term of 60 months. Respondent was ordered that upon release from the imprisonment, he was to be on supervised release for a term of 2 years. Respondent appealed this conviction under case number 19-20697 to the U.S. Court of Appeals for the Fifth Circuit. An interlocutory order of suspension was signed by the Board of Disciplinary Appeals on February 4th, 2020. On January 5th, 2021, a judgment was issued as mandate by the U.S. Court of Appeals for the Fifth Circuit, which affirmed the judgment of the district court. In cause number 19-20697, styled United States of America appellee versus Rodolfo Rudy Delgado appellant. Petitioner's motion for entry of judgment of disbarment was filed with this board on June 4th, 2021. Mr. Delgado was personally served with the motion on June 14th, 2021 by Deputy Jeffrey Jackson, a Tarrant County Deputy Constable. Proof of service of the motion for entry of judgment of disbarment was filed with this board on July 1st, 2021. Respondent is currently incarcerated at the Bureau of Prisons, Fort Worth Federal Medical Facility. At this time, I'd like to offer the following exhibits. Exhibit 1, an opinion issued by the United States Court of Appeals for the Fifth Circuit. Exhibit 2, a judgment issued as mandate by United States Court of Appeals for the Fifth Circuit. And Exhibit 3, the original certificate from Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated July 7th, 2021, which indicates that respondent is licensed but not authorized to practice in Texas. At this time, I ask that the exhibits be entered.
Exhibits 1 through 3 will be admitted.
Then at this time, the commission respectfully requests that the board enter a judgment of disbarment.
Thank you. Any questions from the board? Okay, we will take this matter under advisement. Thank you. And with that, I believe our proceedings for today have concluded. So counsel for commission, you guys are excused and the board will go into conference. Thank you. Thank you, Kim.
Thank you.
Thank you.
Jenny, do you want us to sign off here and go to the conference link? Okay. Thank you.
I think that's safer. Thank